to two particular acts of cunnilingus. It's the State's position, and it's noted in our brief, that issue has never been briefed prior to its arrival in this court in Mr. Crispino's counsel's brief. It was not subject to the petition for writ of certiorari. It was not briefed or argued in the Court of Special Appeals. And quite frankly, if you look at the comments, the objections to the jury instructions that are on page 320 of the extract, it really doesn't appear there. If the tenor of those objections is as to the time frame, I want a special verdict that all of these occurred during the time frames alleged. I want a special verdict. I want a unanimity instruction as to the kissing and or cunnilingus on the child sex abuse charge. So that particular issue, I think, is not properly before this Court, although it does appear in Mr. Crispino's brief in this Court. And so I want to just address that briefly. And that is, again, I think that the Cooksey, this Court's opinion in Cooksey addresses, again, the proposed fixes. This is a pleading problem. And it is not that there was a lack of opportunity to deal with these issues in the beginning of this case. This case went to trial once. There was a mistrial. It went to trial a second time. When it went to trial the second time, some of the counts were dropped out. At that point, this issue should have been raised. Now, I think that there was good reason on Mr. Crispino's counsel's part not to raise them, because it would have put those counts back in, subjected him to further prosecution or additional findings of guilt. And so to sort of sit on everything and then wait and try and fix this with a fix that this Court says isn't going to work to begin with sort of puts the trial court in the position of properly exercising its discretion in refusing to give a unanimity instruction that, A, is an incorrect statement of the law and quite frankly not applicable in this case. So unless the Court has any other questions.
Thank you, ma'am.
Thank you.
Mr. Pavlinic.
Your Honor, this is not a problem of pleading. This is a problem of proof. The pleadings on their face in the criminal information are proper pleadings. The State picked the time frame, but the State introduced proof that varied from the time frame that it arbitrarily selected. And I would have answered Judge Murphy's question the way he framed it, that the judge should have instructed the jury, if you don't find that the events took place during the time frame, that you have to enter a finding of not guilty. That's how I would have answered that question. There is a limit. If, in response to the Court's question, well, why do we even have a time frame in the indictment? Why is there any time frame put in the indictment? There has to be some point, some starting point in which we measure these offenses so that we can garner a defense.
Would the rule be any different? Would our ruling be any different if a bill of particulars had been filed and the time frame was stated in the bill of particulars?
The Court of Special Appeals addressed that issue. The bill of particulars was not a necessity in this case because we had the statements of the children on videotape in which they precisely set forth the time.
No, I'm not suggesting that you needed to file one here or that you should have filed one. I'm simply inquiring about your position on when one is filed. Let's say a bill of particulars is requested and the bill of particulars says, now this child abuse occurred between Christmas of 2005 and New Year's Day 2006. And it occurred in the basement of, I don't know, a department store, a restaurant, a home, whatever it is. And we've got this precise issue. Now, does the fact that the State responded to the bill of particulars in that way mean that the defendant's entitled to a judgment of acquittal if the jury is persuaded that the abuse took place in Thanksgiving, 4 weeks before Christmas, at a different location in the same jurisdiction?
I would say yes,
What case says that?
Well, there's cases that say that the bill of particulars is a limiting pleading, that the state can only prove what it sets forth in the bill of particulars unless, the ubiquitous unless, there is good cause found to expand the bill of particulars. So the bill of particulars is what I liken to a toothless dog that's barking very loudly but doesn't give you the right to go to trial and force the state to prove what's in the bill of particulars because it can be amended. And that's what the state could have done in this case. It could have amended. These could have amended these informations and say, well, we have these time frames now that the children have given, and we could have amended the charges. But they chose not to do that. And they picked the time frame, for example, of the child abuse of Shannon that began in July of 2000 and went to 2001, and there was no testimony of any child abuse occurring during that period of time. So where do we draw the reasonable line? What does Mr. Crispino do? He argues to the jury, well, ladies and gentlemen, there's this time frame set forth in the information, but the trial judge precluded that. He said,
No, that's a separate issue. It's, to be sure, perhaps an important one, but that's going to have to be resolved another time and another place because that simply wasn't presented on appeal.
Well, isn't that built in, Your Honor, to the...
I don't think so. Not at all. The idea that Mr. Defense Attorney, you're not going to be able to argue that these kids should not be believed because we've proven that it couldn't have happened the way they said it happened.
Well, not
how. Trial judge isn't supposed to preclude defense attorney from making that argument, and if a trial judge does,
not how.
Error. So that's got nothing to do with the two issues that have been framed for our decision.
I thought the when aspect of the child abuse was covered by that when we said, well, Your Honor, you have to tie it to the time frame of the indictment. He said, well, you don't have to do that. You don't have to tie the abuse to the time frame of the indictment. And then there was no way to argue the custody component because the custody component then was out of the time frame of the indictment.
Why wasn't there? I mean, why couldn't that be argued?
Well, because the court had told us, the trial court told us that time didn't matter.
Well, time may not matter for purposes of anything other than witness credibility, but time matters very much for witness credibility.
In the jury verdict, the court only said that you have to find that these events occurred. It didn't find that you had to find that these events occurred within the time frame set forth in the information. So if Mr. McDowell would have argued, well, they testified that there was uncontradicted testimony of custody outside of the time frame, it wouldn't have mattered, based upon the way the instructions were given and based upon the way the verdict sheet was structured.
Thank you all.
You're welcome.
Number 12.